Hello everyone, thanks for joining to our live video today again. Today is August 18, Tuesday at 2 p.m. We are here with Leila. Leila, thank you for joining us.
Thank you for having me.
As you know, we always talk about the immigration updates in these live videos, and then in the second part, we keep answering your questions. So we will do our best to answer all the questions asked during the live. And Erdem has just mentioned that we also have one question asked prior to the live. We will also answer that question. Before we get started, do you have anything else, Leila, to mention, or should I just start with
We should start with the news first.
News first. All right, so let's get started. So there was a big decision from Board of Immigration Appeals this week.
Right.
And it is about advanced paroles.
Yes.
And it has overturned a decision that was in place for about 14 years.
Yes.
Can you talk about what has changed?
Yes. In 2012, the BIA, Board of Immigration Appeals, came down with a decision in the matter of Arabelli, which essentially said if you were to leave the U.S. using an advanced parole and you have accrued unlawful presence, that departure will not trigger unlawful presence. So the person would be able to travel. That would be considered a temporary departure from the U.S., and you would be able to come back into the U.S. without triggering the 3 or 10-year bar, depending on how long you had unlawful presence in the U.S. Now, the new ruling in the new case, Del Carmen Lara, essentially overturned that, which means if you leave the U.S., that's considered a departure, and if you have accrued unlawful presence, that's going to trigger the unlawful presence bar, 3 years or 10 years, depending on how long you have accrued unlawful presence. The issue with that is we still don't know how that's going to impact. I've heard that if you come in, it's going to be up to CBP to whether they will allow you to enter the U.S. or they will say you're inadmissible and won't even let you enter the U.S. or let you come into the U.S., claim you're inadmissible, and then if you have an adjustment pending, then you would have to deal with filing a 601 waiver for the unlawful presence.
Okay, so let's step back a little bit and I will try to understand it better. Let's say I have entered the U.S. 10 years ago or 5 years ago, and I overstayed my visa.
Correct.
Okay, and because I was initially given 6 months and then I stayed here 2 years. And after that 2 years, let's say I married a US citizen, right? And I wanted to file a green card application. And with that application, I also filed an advanced parole travel permission. And even though I was overstayed my visa and I was out of the status for some time, during the past term before this last decision, I would be able to leave the US, visit my home country, let's say, and then come back and continue with adjustment of status green card application.
Correct.
Is that right?
Yes. Correct.
I was not at risk of getting denied. But now, since I have overstayed, and the total time is more than 1 year.
Yes.
More than 1 year. Yes. Now they say that the admission ban of 10 years.
Yes.
Would apply to me.
Correct.
Because my travel is not under parole or something, and it's a technicality. But
yes.
If I come back, I would be deemed as departed, yes. And now I am subject to 10-year admission ban.
So initially, the old case said when you leave pursuant to an advanced parole, that is not considered a departure from the U.S. But now they're saying it is a departure, and it will trigger the 3 or 10-year bar.
Okay.
Yes.
So, but luckily, they say that this decision is not retroactive.
Correct.
Right? So if I have traveled prior to this decision and came back, it will not affect my adjustment of status eligibility.
Or if you left right before August 13th and you want to come back now, it will not apply to people who left the U.S. before August 13th.
Okay, so it is at least they give some kind
Yes.
of period. All right. So what is 3 years and 10 years difference? Who will say that I am subject to 3-year ban or 10-year ban?
Yeah, so it depends on how long you've overstayed. So if you overstayed 6 months or more, but under 1 year, it's a 3-year ban. And then if you overstay more than 1 year, it's a 10-year ban.
Okay, for more than 6 months of overstay, I will get 3 year.
Yes.
But if it's more than 1 year, I will get 10-year ban.
Yeah.
So I think it is not the worst idea that you should not travel if you have ever overstayed. But if it is a requirement, if it is very urgent, then you should maybe, if it is less than 6 months, then maybe you can consider it.
The impact, I think the bigger impact of this decision is previously, if we had somebody who came here and applied for DACA, entered without inspection, applied for DACA, and then would apply for an advanced parole through the DACA. Since they entered without inspection, they didn't have an inspection for adjustment. And then we would advise that you can leave on the I-131 for the DACA and then come back in and be paroled in, and that would be considered an inspection and admission, and then you could apply for an adjustment of status from inside the U.S. So this also takes that away.
Yes, so it's the bigger impact.
Yes.
My scenario was about someone who entered with a B2 tourist visa, but there are maybe hundreds of thousands of DACA recipients who entered without inspection and then like they were here illegally, and then they were given DACA, and to be able to adjust based on, let's say, marriage, they had to leave and come back.
Correct.
But now it's not possible.
Correct.
I hope many people have already traveled and came back, so that they are eligible for adjustment, but this is the issue right now. Do we have anything else to mention about this?
Not about this, no.
Okay.
That's about it.
How about the form updates? I know there are many developments impacting students and other immigrant categories.
Yes.
So do you want to talk about that?
Yes, because we have the new F1 and J1 rules, USCIS has now issued new editions for the I-539 and I-765. And these new editions will go into effect September 15th. So any application that is submitted on or after September 15th, you have to use the new edition. Otherwise, USCIS will not accept it. There is no grace period. Starting September 15th, only the new editions will be accepted.
Okay. What is I-539 and what is I-765?
So the I-539 is used to either change your status in the U.S. or extend your status. So as it relates to the new rules for the F1s, as you know, if your I-20 is expiring and you need to add additional time to finish your course of studies, you now have to file the I-539 to extend your stay. So that's the I-539. It could be also used for if you're applying from a visitor visa to a student visa. So it's a change of status or extension of stay. The I-765 is a form that allows you to apply for employment authorization. Okay.
But for I-39, it is not just impacting students. All the immigrants who want to change the status or extend the status in the U.S., they have to use the new edition form going forward after September 15th, you mentioned.
Yes. Any application that USCIS is going to receive September 15th or after September 15th. So it's not when you submit it, it's actually when they received it or when it was postmarked.
Okay, postmarked. So this is very critical. Otherwise, if you, let's say, send your application in the last days and then they reject it, you can be out of status and it might not be easy to correct it.
Yes, correct.
Okay, so be careful. All right, so I also want to talk about the asylum approvals we received in the last few days. This is very critical. Especially, I know many people are concerned about filing a mandamus lawsuit to expedite the decisions in their asylum applications. And I just want to share the beautiful news that we have received many approvals this week. in the last few days, Arlington Asylum Office has approved three clients' asylum applications, and I just want to briefly touch upon those approvals because I know many people are waiting for many years, and it can be very encouraging for them. So, as a disclaimer, Mandamus doesn't give you any guarantee that you will receive an approval, but generally, Mandamus cases are the strongest nudge to USCIS so that they can adjudicate your applications or petitions. So it is not secret that thousands, maybe hundreds of thousands of asylum applications are pending before USCIS asylum offices. And generally after 4 years, you can file a Mandamus lawsuit to get the interview, and after the interview, the decision. And I just want to mention that we had a client who lived in Atlanta, Georgia area, and whose asylum application has been pending in Arlington Asylum Office. We have filed a Mandamus lawsuit for him, and in just 4 years and 1 day, we filed it. And in a couple months, we received the interview. He attended his interview, and while we were waiting for the decision, unexpectedly, USCIS has scheduled another interview. So we went to asylum office again. We went through the interview process. They asked more about regarding the security background check questions. And afterwards, a couple weeks has passed, and then the asylum application was approved last week. Actually, it was approved yesterday, and my client was so happy, so excited. And I also received 2 other asylum approvals as well. One of my clients had filed a Mandamus action at 4 years, but it was maybe a year and a half ago, and it was not successful. Then we have filed another Mandamus lawsuit at 5 years mark, and this time it was successful. We went to attend her interview, and then she got the approval a month after the interview. And finally, I had another client in Fairfax, Virginia area. We filed his Mandamus lawsuit, and a few weeks after getting the interview notice, the lawsuit was successful. A few weeks after we got the interview notice, and the interview was scheduled for a few weeks ahead, and he attended his interview, and just 2 weeks after the interview, he got the asylum approval. So if your case has been pending for a very long time, you are not alone. You can definitely think of filing a Mandamus lawsuit. But I just generally recommend that if you believe in your asylum application, you should consider lawsuit. If you think that your asylum application is not strong, it might not be the best decision to file a Mandamus under this administration, because if the asylum application is not approved, you will very likely be referred to the immigration court, and that process can be very stressful. So if you believe in your case, you don't have to wait anymore. And I know, Leila, you want to maybe talk about other Mandamus success. Yes. We have just received this week, and it was not about asylum.
Correct.
What can we know about that?
So I also want to touch upon a very important field that people are maybe afraid to also apply for a Mandamus. It's the H4 EADs, or any EAD that there have been delays. So I personally filed a Mandamus for a client of mine who is a physician, lives in Pennsylvania, and she basically lost her residency due to the fact that her EAD had been pending for a long time. So she filed a Mandamus case, and shortly after the Mandamus case was filed, her EAD was approved. She's so happy. I just want, because I basically had a consultation with somebody actually yesterday, and they were just a little scared to file a Mandamus. I just want to ensure people that filing the Mandamus is not going to make the government retaliate. It will just help you push your case forward, whether that's going to be an RFE, an interview, or a decision. If your case has been sitting there for a long time, it's just going to make it, give them a little nudge and make them make a decision on your case.
Yes, that is very important, especially now the EAD processing times are much longer.
Correct.
And there is no longer automatic extensions, right?
Yes, and a lot of people are really facing this challenge of losing their employment.
And livelihoods,
Yes,
yes.
correct.
And sometimes insurance.
Yes.
It is very critical. All right, let's switch answering the questions. I think I have a question here. A person asks, these days, how much time is taken for green card of parents they applied in mid-February 2026? So I just want to mention a personal experience, if you don't mind. I had a client who also lives in Fairfax, Virginia, Northern Virginia area, and the U.S. citizen son has filed a petition for the mother, and then it was like 3 months and 10 days that we received the green card approval without an interview. So it's very fast. And so if you have applied in February 2026, it looks like it's been 6 months. It is still normal in my opinion, but in many places right now we have seen approvals in 2-3 months as well. But it is completely normal that process can take up to a year. If it is not adjudicated at 1 year mark, maybe you can consider filing a mandamus lawsuit to expedite that application as well. Do you have other experience?
Yes, my most recent one was a little different. In this case, it was a parent of a U.S. citizen, and they had been in the U.S. for, I think, 16, 17 years without status. And this was filed about a year ago, and just recently was approved, just a little under the 1 year mark, without an interview, which was really amazing because 15, 16 years without status in the U.S., especially after the adjustment of status memo, I personally was a little concerned about it, but luckily it was approved. So I think it also goes back to the circumstances of the case a little as well.
Okay, so in your client's case, it's they had a long immigration history. Maybe
Correct.
Because of that, it took a little longer.
Yes.
We don't know for
Yes.
sure, but based on our cumulative experiences, it's like 3 months to a year.
Yes, a year. Yes.
Okay. All right. Let's switch to the questions asked during live. All right. Emma Thomas. How long does it usually take for an I-130 to be approved? We have been waiting for a year now. Is there anything we can do besides filing a mandamus? The spouses are living separate countries. So let me say this, if there is an I-130 pending and it is just I-130 only petition, meaning that the beneficiary, the spouse, not in the US
Correct.
and overseas, and there is no I-485 pending because of that, it can take 12 to 15 months easily. And the current processing times website shows around how many?
I don't even know, 50 months, 60 months? Yeah, it's taking a very long time.
I don't know, maybe it's more than a 10 year, I don't know.
Was it the one we recently checked that
Yes,
said 139 months? Was it that one?
I believe it was that one.
Yes.
So processing times website is not accurate for sure, but it can take more than a year. And I generally recommend filing a mandamus after a year. But it is still normal up to 15 months based on our experience.
And we don't even know if this is for a spouse of a U.S. citizen or a permanent resident. So
yes, spouse of a permanent resident is also kind of similar to the U.S. citizen spouse because there is almost no backlog in F2A category. Other than filing a mandamus,
yes.
I don't see much options. If you reach out to congressman, you generally receive standard answers, not very helpful. If there is an emergency, like medical emergency or something, you can definitely try to do expedite request.
Correct.
But most of the time they are arbitrary and not very helpful, unfortunately.
Especially in this administration, I think it'll be a little difficult.
Yes, yes. Do you want to take the other one?
Yes. I became a U.S. citizen and returned to my home country 1 month later. Will I have any issues when I re-enter the U.S.? I'm waiting for my spouse's I-130 to be approved before I return. So as a U.S. citizen, there is no physical residency requirement in the U.S. anymore. So you can basically live anywhere for any amount of time in the world. In this case, the only concern would be if you have an I-130 pending for the spouse, at some point when the case is with the NBC, you have to prove that you're domiciled in the US. So you would have to show that your intention is to live in the US. But as far as the US citizen is concerned, there is no requirement for you to live in the US. You can live anywhere in the world.
Yeah, there is so much fear that even US citizens are kind of scared. Yeah. I can definitely understand. And as you mentioned, for the I-130 petition to be approved, actually for the immigrant visa to be approved based on I-130 petition, the US citizen petitioner has to show that after the beneficiary was given a visa, then they would definitely relocate to the US, and they are just waiting that. And to show that, I think having strong ties with US is very important. Correct. Maybe having a valid driver's license, lease agreement, maybe job offer.
Yes, correct. And
sort of things.
That would be required at the time of the appointment at the consulate. If the spouse is living outside, then they would like to see evidence that you have the intention to come back and live in the US.
Definitely. I think we have same question again. This is EB2, and maybe you want to take that one.
I have EB2 NIW interview. What kind of questions should I expect? What kind of documents should I bring to the interview? So for the EB2 NIW interview, I would expect questions regarding the proposed endeavor. I would expect questions about my background, anything that was mentioned in the petition letter that was submitted with the NIW. I would have that prepared and ready to answer all those questions and have all the documents that were submitted with the petition. I would generally take everything.
Yeah. So I think I would like to mention that under the Biden administration, there was no employment-based interviews at all. And the question is not clear whether the I-140 is approved or yet. Yes. So if the I-140 is approved, I would be a little bit less stressful because the I-140 petition is already approved. And sometimes I remember one time attending an EB1 adjustment interview, and there was the I-140 was already approved. Yes. But the officer still asked a couple questions, not very detailed. Yes. But the I-485 only is generally about the background checks, address history, employment history, familial history, and stuff. So you should definitely know your answers in the form I-485, and you should have all the information and documents ready. But if the I-140 is still pending, then you should definitely work on the petition, try to remember what was provided to immigration office, and you may need to explain your proposed endeavor and your plans in the US.
Correct. Yeah, in this case, because he said EB2 NIW interview, I'm not sure if the I-140 is approved, but I recently did have a client who attended an adjustment interview based on an EB2 perm. And not only was he asked questions about his adjustment application, he was basically asked questions about his role, his position. So as you said, in the previous administration, there were no interviews for employment-based, and the officers weren't even trained for these types of interviews. But recently I've been hearing that officers are asking a little questions about the I-140s as well, even in the adjustment interviews. Yes.
Let me ask you this. Did you ever see an interview for I-140 only petition?
I have not, no.
Me neither. So definitely there should have been an I-485 involved in this situation,
Yes.
but we don't know for sure whether I-140 is approved. All right. Let me take this one. Arrived on F1. USCIS got my application on exact 1 year deadline with FedEx proof, but returned it for a missing photo. Resent immediately, but marked 12 days late. Will I be referred to the court? Since he has mentioned that 1 year deadline, I am assuming that it's an asylum application. Yes. And it is so unfortunate that there was a missing photo involved. I am hoping that it was a pro se filing, not an attorney made this mistake. I generally, so 1 year deadline is kind of critical. And you can argue that if it was an attorney's mistake, it is not in your hand. And you can argue that, and you did your best to file it timely. Sometimes they might accept it, sometimes they don't. So you should also try to make argument if there is available ground for it. Let's say you had waited that long because you were expecting, a shift in your country's policy, whatever. That, like, if there is any other ground for the 1 year rule exceptions, you should definitely keep that in mind. You should talk to your attorney and try to understand the situation better. And there might be an exception for you. However, if you are asking this question regarding the most recent policy, saying that if there is a 1 year issue, we might not even interview you, we will just directly refer you to the immigration court. I haven't seen those referrals in bulk yet, so I cannot make an estimation about that. But even if you are interviewed, you might be at risk of being referred to the immigration court. You should do your homework, understand the background regarding the 1 year and exceptions, and you should do your best to not get referred to the immigration court. It is very critical. I would be a little worried about your situation. Do you have anything else to say?
Sometimes when USCIS sends a file back, they send like this green paper and they say there's a deficiency, put this on top of it and send it back. And usually that green paper comes with another notice that has the date on it. Does that help in a situation like that?
I think definitely an argument has to be made, and it would be a great evidence, including the FedEx receipt proof. So I would definitely make that argument. I hope that you received the deficiency notice. Yes. You probably have received it. So you can say that you did your best to file in 1 year, but because of just a procedural mistake, there was an issue, and you corrected it, resending in 12 days. So it is kind of discretionary, but if your officer is kind of nice enough, you have chance. Okay, Murat Berdiev, I have two quick questions. My OPT EAD has been pending for 3 months and a half. Could the current administration affect my chances of OPT approval? I never received an OPT denial yet. Did you ever receive an OPT denial? So we do not see much issues with OPT renewals or OPT applications. I am not worried that much unless there are extraordinary circumstances.
Right. Yes. If you haven't filed in time.
Yes.
Yeah, but other than that, it should.
Or if you have criminal history,
yes,
and stuff, or work without authorization, I don't know.
Correct. Yes.
So. Also, does the new F1 rule affect those transitioning from OPT to STEM OPT, and what should they do?
I think the new rule had some grace period for people who are transitioning from OPT to STEM OPT. And if you file, if it's less than 180 days, you don't need to apply for the I-539. You just file for your regular I-765.
Okay,
Yes.
that's good to hear. Ahmet Dalkıç says, I entered legally and have a pending asylum with proof of criminal case against me back home. If I marry, can I use the future persecution exception to avoid consular processing to under the I-485 memo? Is this realistic? So I wouldn't worry in your situation, because the memo says if there is a humanitarian reasons, it's an exception. And I should mention that even after the memo, we never received a denial, because the initial entry was a non-immigrant visa. So they are not enforcing the memo very strictly.
Correct. Yes, there was a lot of pushback on that memo, and I believe that they're really not imposing that memo on anybody. It's just that they're not taking it back, but they're really not acting on it either.
Yes, definitely. So no need to worry that much. Also, would it help that my spouse has served in the U.S. military for 10 years and is still serving? Yes, these can also be used as favorable discretionary factors.
Yes.
Okay. My wife is a U.S. citizen and a veteran. I entered the U.S. without inspection, crossed the border illegally, and my case is currently ongoing. We live in Maryland. We filed the Parole in place I-131 form, and it began processing in March. Now we are about to file the I-130 petition. I feel like we are late in doing this. Regarding the I-485, my lawyer thinks we still need to wait. He says we should apply only after the PIP is approved. Do you think my case is proceeding correctly? In the best case scenario, how long would it take for me to get a green card? Thank you for everything. So for parole in place, I think it is kind of smart to wait until parole in place is approved first, because I-485s are being adjudicated very quickly. And if you file it, and if the parole in place was not approved by the interview time, then they might have to deny your I-485 based on the admission.
Correct.
Do you think?
Yes, I agree. I think it makes more sense to have the parole in place approved first.
But definitely talk to your attorney, or if you want to get a second opinion, you should provide the documents and history to another attorney, and it might be complicated to answer like fully your question in a
not knowing
social media live. Yes. So I think these are duplicate questions. Okay, so is it David Stavern? My advanced parole, I-131 application pending for 8 months. I need to travel to Turkey for 1-2 days at the end of September to attend an important internal company examination that required to take. How can I request Expedite? So to request expedited processing, you have two options. Either you can call USCIS 800 number and try to reach to a live representative, and the second option is you can try to go to my USCIS.gov, and you can try chatting with the tool called Ask Emma. Mm-hmm. Is that right?
Correct.
So and you need to mention the background about the expedite request. Generally, medical or humanitarian reasons can be a reason, and the other reason can be a big financial loss.
Yes.
So if you have if you are at risk of big financial loss, they might expedite it. And if it's been pending for 8 months, and if the travel has to be at the end of September, I would recommend filing a Mandamus lawsuit if you have budget. It's the most effective way, because expedite requests are not very reliable. They sometimes deny it very arbitrarily. You have no options to kind of appeal it.
Correct.
So if this meeting or internal company examination is very important for you, I would file the Mandamus right now. And for example, I have many U.S. Attorney's Office attorneys friends there. I can reach out to them saying that, oh, I know you have 60 days to respond to this lawsuit, but there is an emergency. Can you please help talking to your client, expedite this application? So if this is very important, I wouldn't just rely on the expedite request, and I would file a mandamus lawsuit if I have the budget for it.
Correct. Yes.
Do you want to take this one?
Applied for asylum, then dropped out, but school terminated my SEVIS for attendance/academic failure instead of voluntary withdrawal. Would this negative SEVIS status hurt me at the interview? Am I missing a?
No, I think they're asking about asylum interview and whether the SEVIS termination has any effect. I think this is the same person who asked about the 1 year deadline issue. I remember the little icon, little general name. So no, as long as there is no asylum bar issues, you should be fine. It's not very important regarding the reasoning for SEVIS cancellation.
Because maintenance of status is not an issue when it comes to asylum, correct?
Yes, to the point, definitely. So you don't have to maintain your status. So you just need to be careful about 1 year deadline, and you don't have to worry about the SEVIS issue. Guys, please don't forget to like the stream, and Erdem has mentioned it in the chat. I appreciate it. And also, if you can subscribe to our channel, we would really appreciate that. And if you have friends who are in need of clear immigration advice, then they can definitely, you can definitely share our Immigration Champion channel with them as well. Do you want to take this one?
I'm not sure.
Yes, Edward.
I came without parole at border in January of 2024. I was issued ORECG56. Apparently, I was required to report to ICE for an appointment within 60 days, but I learned that now. Okay. What should I do, and what could this cause? I think this is for you.
Okay. So if you were given an appointment date with the G56 form, you are supposed to go to ICE for check-in, right? And if you do not appear for the check-in, they think that you intentionally did not attend your appointment. And if you, God forbid, let's say that if you are detained by ICE, you can request bond. And during that bond hearing, the immigration judge can say that, oh, you did not attend your ICE check-in prior, and I think that you are a flight risk and I am not giving you a bond. So this might be the case for you, and it can be critically important. On the other hand, if you request a meeting with ICE right now, you are also at risk of detention. It is scary as well. So either way, you should talk to an immigration attorney, provide your documents, and if you are at risk of detention, you should also find a sponsor for the bond process, and all the information and evidence should be provided to the attorney. And in case of emergency, you should designate a point of contact with an attorney. Then if something happens to you, they can directly reach out to that attorney. Evidence and documentation will already be shared, and then you should be more secure, safe, because an attorney can take an immediate action by filing a bond motion or a habeas corpus petition to protect you from transfer and more problematic issues. So I think you should definitely talk to an immigration attorney. And if you reach out to our office, you can say that you are coming from the live stream and you want to just take the precautionary action, and you want to share the documents and information regarding potential detention. We have many clients who share their information with us, and in case something happens to them, we can directly take action for them, even during the weekends. So we have people working over the weekends now. So we know that ICE doesn't take some days off. So we try to do our best to take action even those days.
So what is the first step if they're detained? Is it that they have to immediately let ICE know that I have an attorney, I'm being represented?
So generally, if they are detained, they should call someone from, maybe it can be a family member or a close friend, and give the attorney's name, and the friend or the relative can call attorney, inform them, and if they have the documents, that would be helpful, because an attorney can see the location of the detainee by checking the alien number. So if you can share your documents or alien number with that friend or relative, that could be helpful. And based on the circumstances or entry type, if it is a entry with a visa, the process can be different. Or if it is an entry without inspection, then we sometimes recommend filing a federal court habeas action right away, because sometimes filing a bond motion is unnecessary. It is very clear that immigration judge is not granting bond. So it depends, but definitely have someone reach out to attorney. So if you tell ICE that you have an attorney, it doesn't make much difference for them.
Understood. Okay.
The attorney has to take action as soon as possible. Okay, do you want to take this one?
I have a pending I-485 through an approved EB-2 NIW. My J-1 status recently ended, and my fiance is a green card holder. Would it still be possible to apply for a marriage-based green card after my J-1 is ended? Well, that really depends on whether if the person is subject to the 2-year residency requirement or not.
Let's assume there is no 2-year residency.
Then you can apply for your green card through marriage base.
But it's just I-485 pending. There is no underlying status. Do you think still they can apply?
For a marriage-based green card, so they can apply for an I-130 and an I-485, or they can continue with the 485 that's filed through the EB.
Yeah, so since the petitioner is not a U.S. citizen, I think the question is, if you no longer have a J1 status, technically you don't have a status. You are staying here with just I-485 pending, right?
Correct.
Then you can, since you are not in status, and I-485 pendency gives you kind of authorization to stay, but it's not a status.
Correct.
So I wouldn't lose my J1.
Unless it's in the 60-day grace period, correct?
Yeah, okay.
So if the J1 has ended and we're in the 60-day grace period, if you don't travel after September 15th, because then the grace period will go down to 30 days, correct?
Yes.
So unless it's in the 60-day grace period, at that time he can apply for I-130 and 485 through the green card holder. It has to be a spouse, not a fiance. And then that would be fine. But if he has an approved EB-2 NIW,
is it really needed?
It's really...
So unless there is
a backlog,
yes, which is not the case for rest of the world, right?
Yes.
Right now.
Yeah.
So I-485 can take up to a year, sometimes much shorter.
EB-2 NIW, if you're from India, there is a backlog. But if you're doing a marriage...
I know, I think the name is Turkish. So,
Turkish, okay, so there shouldn't be a backlog.
Yeah. So we wouldn't spend any money or resources for a green card petition based on a marriage in your situation, and I would just continue with I-485.
Correct. Yes.
Based on EB-2 NIW.
Yeah, and the benefit is also that if you file through your spouse, you get a conditional green card for 2 years, and then you would have to apply for the removal of condition. But if you're applying through your employment base, then your green card is not going to be conditional.
Yes. and after 2 years you have to spend time and money
Yes.
for I-751 as well.
Correct.
But if you get it through NIW, it will be
A permanent,
permanent 10-year
yes.
green card. So if we were you, we wouldn't do the marriage-based.
Yes.
You don't have to touch
Yeah.
you have, every possible avenue. So, Mr. Arif, the August and September visa bulletin numbers were given very high. August 29,000 and September 47,000. Can the suspension before September 30th be cancelled? So I don't want to make any speculation here. I think this person is asking about the pause regarding diversity visa process, and the Trump administration doesn't give us any signals whether they will terminate that ban policy. Unfortunately, I cannot make any estimation, but if you, there is not much time left until September 30th, but if you want to do the individual lawsuit against the government, there might be an option, but I am not taking those cases because the chance of success is very slim. Okay, another person. I came to USA unlawfully, no parole, applied for asylum after 8 months, still asylum pending. So now I am married to a US citizen. How to avoid 601 waiver? Is voluntary departure, does voluntary departure help? So if you have entered unlawfully and if you without parole, you cannot adjust your status based on marriage to a US citizen in the US. You have to leave at some point. And if you have spent more than 6 months in the US, you are subject to 3-year ban, 3-year entry ban. And if you apply for asylum after 8 months, you are not subject to 10-year ban, because at 8 months mark, your unlawful presence has stopped. Correct. In my opinion. Yeah. But it is very likely that you are still subject to 3-year ban. And do you want to talk about the 601 waiver, or is it possible to avoid 601 waiver in this situation?
If he's going to use the route to get married to a U.S. citizen, he would definitely need to apply for the 601A waiver, actually. So essentially, he would have to file an I-130. Once that is approved, then he would have to file for the 601A. And once that is approved, then he would have to go outside, attend an interview outside, and then pick up his immigrant visa. I have done these in the past, not in this administration, but in the past, and they have all been successful if you have the elements for the waiver. I'm not sure how it is going in this administration and if people are picking up visas at the consulate with a 601A during this administration. But he also has an asylum pending, right? So if he has an asylum pending, that's asylum, I'm guessing, with USCIS, because it was 8 months?
Maybe immigration court, it can be either.
So how would that impact filing for a 485 now? Would he have to first do something with that?
So they cannot file I-485 because they entered unlawfully.
Yes.
So the admission, whether the asylum application is pending before immigration court or asylum office, it doesn't matter. Yeah. You entered unlawfully. And since he's talking about voluntary departure, I am guessing that he's in removal proceedings. His case is with the immigration court right now, not USCIS. And even if the 601 is approved, 601A is approved, even if that is approved, so there is no 3-year ban applying to you, and if you go back to your home country to get the green card visa, then the consulate officer can ask you whether the asylum application was truthful, in my opinion. Am I right?
Yes.
Because you applied for asylum, now you are back in your home country. How would you explain it? Did you ever file a frivolous asylum application? So you should be prepared for those type of questioning, and if there is a change in your home country after you filed for asylum, then you can explain it that it was dangerous before, now it is safe for you, so that you were able to travel. But without a 601A waiver, we don't see any options available here.
Yes, I don't see any option. And even if he takes a voluntary departure, he still has to leave.
Yes, yes.
So,
You are still required to leave, and voluntary departure does not prevent 3-year ban.
correct.
Yes. All right. Thank you, everyone, for joining us. We were happy to answer all the questions here, and we will be live again next week at the same time. Thank you, and please have a safe week ahead.
Yes, thank you so much.
Bye-bye.
Bye.